Ms. Hawkins, as you're sitting here right now, do you feel that you're under the influence of any alcohol, drugs, prescription medications, or any illegal substances that might cause you to either be confused or unable to understand today's proceedings, or to assist your attorney should they desire your assistance?
No, Your Honor.
Thank you. The record should reflect the court has had available for its complete review the pre-sentence investigation report. Summaries of said reports have been provided to both counsel of record. State, I'll start with you. Have you had an opportunity to review the summary of the pre-sentence investigation report? And if so, are there any additions or corrections?
We have reviewed it, Your Honor. No additions or corrections. We're ready to proceed to sentencing.
Thank you. For defense counsel, either Ms. Carrington or Mr. Walker as well, the same inquiry.
Thank you, Your Honor. We've reviewed the pre-sentence investigation, no additions or corrections. We are also prepared to move forward with sentencing.
Thank you. With that said, State, would you like to be heard?
Yes, Your Honor. In this matter, the plea negotiations had a stipulated sentence of 30 months in count 3 to run consecutive to 30 months in count 5 to run concurrent to 30 months in count 7 for a total of term of incarceration of 60 months or 5 years, Your Honor, total. The state of Ohio came to that conclusion in light of all the evidence looking at what involvement Ms. Tien Hawkins had compared to that of Mr. Brian Moser, and that's how we came to the conclusion of the stipulation of the 5 years, Your Honor.
Is there a reason that the one so there's 3 different children in counts 3, 5, and 7. 30 months are recommended and agreed on 2 of those counts, but the 3rd count is concurrent. What was the basis of the 3rd child not having a penalty factor?
So basically, the reasoning for that, Your Honor, is we're going to do 15 months on each. However, that's not allowable under the laws for F3. Those 2 children, they were kind of treated the same in regards to her actions and that, and so we wanted a 30-month total for those 2, but we couldn't do it by 15 and 15, and then otherwise we'd have been left with 12 and 18, and that wouldn't have made sense either, because then one would have been more than the other, so that's why we did 30 to run them both concurrent, so we still got the 30 that what we wanted or intended to get for those 2 children, but there was no way to get that with the current allowance of times under the law to make it be the same, and so 30 months concurrent made it the same, and we still got the 30 months, Your Honor.
All right, thank you. Defense, would you like to be heard?
Yes, Your Honor. Thank you. We are asking the court to follow the agreed 5-year sentence. I think there's no doubt that this case presents an unimaginable tragedy, Your Honor. But Ms. Hawkins is 26 years old. She has no prior criminal history, and I think it's important to distinguish the intentional acts of Mr. Moser versus Ms. Hawkins's involvement with the failure to protect the children. The majority of the abuse that was happening was occurring while Ms. Hawkins was at work supporting the family, and she entrusted Mr. Moser to become the full-time daycare provider for the children, unbeknownst to her of the horrific things that were happening. And I think Ms. Hawkins shows a genuine remorse for what's happened. She's able to realize now what she didn't realize at the time. And it's important to note that she has a family here that's provided unwavering support for her. They've attended every hearing. We've provided letters not only from her family but from the community, trying to show the court what kind of person Ms. Hawkins is and what she is capable of providing to society. We think no matter what happens today, when Ms. Hawkins leaves here today, she's going to be stuck with a life sentence of guilt and remorse. But we are asking the court to follow the 5-year agreed upon sentence. We think it serves the principles of sentencing. Thank you, Your Honor.
Thank you. Mr. Walker, will you be supplementing any of the arguments?
No, Your Honor. I would submit on what Ms. Carrington's already argued. Thank you.
Will there be any, and the same applies to the state, will the state be presenting any witnesses outside of just arguments of counsel?
No, Your Honor.
Okay. Will the defense be presenting any witnesses outside of the arguments of counsel?
No, Your Honor. Thank you.
You're welcome. Ms. Hawkins, under Criminal Rule 32, you're not required, but you're entitled to make a statement on your own behalf if you wish to make a statement. I realize that you've given a statement to the officers that prepared the pre-sentence investigation report, but is there any statement you'd like to make today, ma'am? And if so, now would be the appropriate time.
Just that I love my children and I wanted to give them the best life I possibly could. And if I knew what he was doing, it would have never got as far as to what it did. And that I would still have all 3 of my children.
Ms. Hawkins, how did the child that passed, Lilith, how did she get placed without any, when you learned of her death, you put a diaper on her because she didn't have any clothes on?
Yes.
Why wouldn't she have had a diaper on the night before, or some kind of clothing the night before?
We were trying to potty train her, so we were trying to get her used to not wearing diapers. And, we didn't have any clothes to put her in. And,
Okay. All right. Thank you for answering my question, ma'am. Anything further?
No, Your Honor.
Submitted?
Yes, Your Honor.
The court notes on this 17th day of June of 2026 that the defendant's sentencing hearing was held pursuant to Ohio Revised Code Section 292919, and present in court was defense counsel, Ms. Mackenzie Carrington, as well as Mr. Jonathan Walker, assistant prosecuting attorney, Mr. Tyler E. Cantrell, the madam prosecutor, Ms. Ariana Bowles-Norris, as was the defendant, Ms. Tien Hawkins, with Ms. Hawkins being afforded all rights pursuant to Criminal Rule 32. The court has considered the record, the oral statements, any victim impact statements, and the pre-sentence investigation report prepared, further reviewing the various letters that were written in support of Ms. Hawkins. And further, the court is considering the principles and purposes of sentencing under Ohio Revised Code Section 292911A, which sets forth that a court that sentences an offender for a felony shall be guided by the overriding purposes of felony sentencing. And the overriding purposes of felony sentencing is to protect the public from future crime by the offender and others, as well as to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden upon the state or local governmental resources. To achieve those purposes, the sentencing court shall consider the need for incapacitating the offender, deterring the offender and others from future crime, rehabilitating effectively the offender, as well as making restitution to the victim of the offense, the public, or both. Further, this court will be balancing the seriousness and recidivism factors under 292912, noting that it would not sentence Ms. Hawkins nor any other defendant before this court based upon their race, ethnicity, gender, or religion. The court does find that the defendant has been convicted pursuant to voluntary pleas of guilty in count 3 to child endangering in violation of 2919.22A, that being a felony of the 3rd degree, and count 5 to permitting child abuse in violation of 2903.15A, that being as well a felony of the 3rd degree, and in count 7 to permitting child abuse alleged in violation of 2903.15A, that being a felony of the 3rd degree, all of which subject to Division A of 292914 of the Ohio Revised Code. The court notes that pursuant to plea negotiations between the parties, counts 1, 2, 4, 6, and 8 having previously been dismissed. Of course, many police officers were called to the scene, and so the court went through those various ones, and I think the one that captures the majority of it is this, that on July 1st, 2025, a sergeant was called to Timber Ridge Apartments, apartment 15, regarding a 911 call being a 2-year-old female non-breather. On arrival at the apartment, the sergeant asked the male standing at the door where the baby was. He advised the baby was upstairs. They started up the stairs. Another sergeant, Walters, was carrying the 2-year-old down the steps. He then laid the baby down to start chest compressions. As Life Squad pulled up, Sergeant Walters then ran to the squad with the baby. Deputy Sean Grooms also was there, and he went inside the apartment to look around to see if he could observe anything that would have stood out in the case, that something like the baby got a hold of something. They were able to let the squad know. While upstairs, Sergeant Phillips went to the bedroom to the left, in which there was a small crib up against the wall. It was then determined they weren't in the correct room. The room the baby was in was the room with the bunk beds. Sergeant was able to do a search, as well as any further squad members needed important information from the mother of the child, which the 2-year-old had been confirmed deceased at that time. They received information and gave it to the squad members. They also had Tien Hawkins, along with a 5-year-old child and a 1-year-old baby, sit in the back seat of the unmarked car. They did take possession of her phone. The male adult being Terry Michael Smith, the third, also known as Brian Moser through his name change, which is the name that he had recently gotten changed the day prior to the incident. Brian's phone was also confiscated, and Deputy Grooms took possession of the 5-year-old and the 1-year-old. They did observe the 1-year-old having severe bruises at the top of her forehead, along with bruises on her legs. The child was in a diaper only. Sergeant Phillips did get consent from Tien Hawkins to do a DNA swab on her ankles, in which she indicated there was blood through female cycling. Tien Hawkins was then read her Miranda rights, and she did not consent to swab her ankles, and again to see where that blood was the source of. Children's Services took custody of the 5-year-old and as well as the 1-year-old. Both children were checked out by the squad, and pictures were also taken of the bruises the kids, these 2 children, had on their bodies. They transported Ms. Tien Hawkins to the sheriff's office for interview. At approximately 10:38 a.m., Detective Cooley interviewed Ms. Hawkins, the mother of the child that was found deceased, also the mother of the 5 and the 1-year-old females that had also had signs of bruising and beatings. Detective Cooley did read Miranda rights to Ms. Hawkins, in which she said she would answer questions and give a statement. She advised that around midnight the kids went to bed, were put to bed, all the same covered up and tucked in. Tien advised that the last time Lilith was awake was around 11:30 p.m. She was running around playing. Tien Hawkins stated that she does not have any medical conditions. Also advised that they were working on potty training her. She said that they had tucked the children in bed, that she knows nothing about the knot on her forehead, and doesn't know if she turned and hit her head on the metal of the bed or what happened. She also said her fiance, Brian Moser, woke her up, telling her that Lilith wasn't moving. She ran into the bedroom. Lilith was taken off the top bunk by her, being Ms. Hawkins. Tien stated she started CPR on Lilith. Tien then said that Brian and she did smoke a THC vape around 11 p.m. while the kids were watching TV. Ms. Hawkins stated that she didn't do anything to Lilith, and also advised Lilith that didn't have that bruise when she went to bed on her head. Stated that Brian disciplines the children more than she does, that Brian watches the children while she works. Tien did say that Brian does bust their butts, and said that Ms. Hawkins personally works a lot. When she had gone to sleep, being Ms. Hawkins, that she felt Lilith was fine. Brian tucked her in, doesn't know if it was too tight in the blanket. She said she did put the diaper on Lilith after she had tried to do CPR. She said this was done because she wanted her covered up. That way she wasn't completely naked. Tien then said Brian was a little more tough on her, more than the other children, being tougher on Lilith than the others. He busted her butt every time she used the bathroom in her pants. Confirms that she knew sometimes that he had whipped her too hard, to the point that she was actually told him that it was too hard, and she has no idea how this happened with the death of Lilith. She's seen Brian push her, and she's seen her fall to the floor. This occurs when she does not control her bowels, being Lilith, and she doesn't go to the potty. He pushes her, and she's fallen down, denies the fact seeing him hit the children anywhere but their butt. Terry Michael Smith III, also known as Brian Moser, was read his Miranda rights. He stated that he had changed his name because he likes the character from the TV series Dexter. He said that he put all the kids to bed around midnight. He then went to bed with his fiancee Tien. She was already asleep, being Tien. Brian said that Aurora was to the left of the bed, Lilith was in the middle, and Isabel was on the right. He thought it would be cute for all three of them to be up on the top bunk like that. Detective Cooley explained to Mr. Moser about the bump on the head and asked about that. It had to be a hard impact to cause that type of bruising. Brian Moser said, "I did not hit her in the forehead. I did not. I could put that on everything. I don't recall hitting them anywhere but on their butts, hands, or their mouth. I did not close fist hit them. I don't do that." And it concludes by saying that Deputy Cooley advised that this isn't Dexter, this is real life. The statement of the defendant is as follows. Me and Terry got together April the 8th of 2025. He was really sweet in the beginning. I'm not exactly sure when everything decided to change. I think it was after we went to go to put him on the lease. He would be much stricter after that. He watched the girls while I was at work. I asked the girls how their day was when I would get home, and my oldest would always say they played, it was good and they played. The children, by Ms. Hawkins' statement, they never showed any kind of fear towards Mr. Moser, that they would go up to him, sit in his lap, and loved all over him. Then he got his name changed. Then that night he had put them to bed, and they all fussed a little bit, but they always fussed going to sleep. Then he told me he was going to get up in the morning, get them ready, and fix them breakfast. He was going to let Ms. Hawkins sleep in since she had worked later that day. Then in the morning, when that morning came, Mr. Moser told Ms. Hawkins that Lilith was dead. Ms. Hawkins then ran into the bedroom, grabbed her off the bunk, being Lilith, and started CPR on her. He was holding, being Brian Moser, was holding Isabel and told Aurora to go upstairs. Ms. Hawkins told Mr. Moser to call 911 because he was just standing there looking at her. He kept telling her that he was sorry, but he never said what he was sorry for. Then they had come and checked on her. She put a diaper on her because they couldn't find pants. She had just let her sleep naked because they were going to do laundry the next day. Then Ms. Hawkins advised she was questioned, stayed the night in jail that night, and then she was released the next day. She was home for approximately a week when they picked her back up, and she's been in the Adams County Jail since. She closes her statement by saying, "I love my girls very much. I just want them, I want to give them the best life that I could. I miss them, and I hope that someday I get to see them again." The defendant's attitude was cooperative through the interview process for the preparation of the pre-sentence investigation report. Ms. Hawkins has served 345 days as of today's date of June 17th, 2026, for which she's entitled statutorily to credit against any sentence imposed. The family history: Ms. Hawkins was born on May the 22nd, 2000 in Brown County, Ohio, to Karen Sue Hawkins and Scotty Stanford Hawkins II, both of West Union, Ohio. She currently resides in West Union. The defendant has two biological siblings, with the defendant being the second of the siblings born. Her parents have never been involved with law enforcement interaction. She rates her childhood overall as good, with no history of abuse or neglect. She has never been married, not currently in a relationship, has 3 biological children, with Jason Burkhart being the father and being in foster care placement. Aurora, 6 years old, Lilith, 3, who's now deceased, and Isabel, 2. The defendant has had previous CPS involvement for Aurora, going to school and telling them that her dad beats her. But defendant stated it was a misunderstanding. And the second time CPS was involved was for their home being nasty. The defendant stated that she has 2 close friends, one she has contact with once every couple of days, and the other she has contact with once every 6 months. Neither friend has ever been in trouble or engaged in illegal criminal activity. She does not have otherwise acquaintances, stated she's never been affiliated with a gang. The defendant reported that she completed the 12th grade of education at West Union High School at the Ohio Valley Career and Technical Center in 2019. She reported that she was never expelled or suspended from school. She has the following additional education certifications. She has culinary certification and ServSafe. She does not have any military history. She rates her health as good, with some current medication prescribed for depression and anxiety. The prior substance abuse: the defendant reported that she tried alcohol once at the age of 16 and would have less than a cup of a mixed drink, but does not drink regularly, with the last time being December 31st of 2025. She reported that she did smoke marijuana daily from the age of 18 to the age of 25. She's never participated in substance abuse treatment. Her employment history is admirable. She has utilized her certification in culinary certification and ServSafe in her food and beverage training. She has been a manager at both McDonald's and KFC Taco Bell. At McDonald's between the periods of June 2023 and June 2025 for in essence a 2-year period. At KFC from August of 2018 until June of 2022, a 3.5-year stint. And then in between, she worked with Subway as a line manager and cook. She reports currently having no monthly income or expenses, that when she was employed, she could pay her bills. As most adults, she sometimes worried about her finances and struggled to make ends meet. But otherwise, she was able to manage her debts. Recidivism, as to whether it appears based upon the assessments whether she's likely to recommit offenses, criminal offenses, it rates as low. The recidivism factors whether the offense was committed while on supervision or community control with any other courts or institutions. That does not apply. Whether she has a history of criminal convictions or juvenile delinquency adjudications, she does not have any prior felony criminal convictions. Whether she responded favorably to sanctions previously imposed in adult or juvenile court, there are no, because there's no prior record, there's no violations of the sentences in those cases, and she has not violated her bond. The next factor, whether she shows a pattern of drug and alcohol use related to the offense and doesn't acknowledge or refuses treatment. She does not show a pattern of drug use related to this offense. And lastly, the question of whether she has genuine remorse for her actions or for lack of actions in a sense in this case. They do say, the assessors do feel that she shows genuine remorse. She scored 10 or low on the Ohio Risk Assessment System, indicating a low risk of reoffending. The court notes that, and had earlier noted that it did receive and reviewed letters from a former Sunday school teacher of Ms. Hawkins, who has stayed involved in her life to the extent that she could, always showing, I guess, structure and mentorship, and also she indicates that Ms. Hawkins was always receptive and always kind and respectful to her children. There's also a second letter from the sister who sets forth her relationship with her sister. And then there is a Mr. Fox, or Jesse Fox, he or she, that gives a statement of credibility in regard to Ms. Hawkins. And then lastly, there was documentation received that during her 345 days incarceration that Ms. Hawkins has been a model prisoner for the Adams County Sheriff's Department, and that she's also seems to, it's joined in that there is remorse that's shown, that she carries a folder with the pictures of her children with her and often refers to them. With that said, the questions that I had about following the stipulation of sentence was why the third child was treated differently. The court has struggled with whether a 30-month sentence should be placed on each child. And again, I think I don't find that to be harsh when we look at the realities of this. And so that's the court's concern, and then also how the child ended up. And I realized sometimes children sleep naked, but there was just no guardrails there. And I ask in cases sometimes, would you go to the grocery store and sort through all the apple bin and pick out the bad apple and bring it home to your children? And parents, mothers always say no. But you sorted through the apple bin and found this Brian Moser, bad apple. You knew he was a bad apple. You saw the change in his behavior, and you didn't put up any guardrails. And I struggle with that. Do you want to comment on that? You don't have to. Okay. Well, sometimes the court has to consider what the citizens and the community partners, what they have observed, what they know, what they have experienced, that they have interacted with Ms. Hawkins. This court, obviously, it's been very limited that the court has interacted with Ms. Hawkins. I do believe that Ms. Hawkins has great remorse for what occurred. There is a high likelihood there will never be recidivism in this case. Even in light of the court's concerns as to the variation in the agreement, the court does find comfort, especially in your in the very well written letter by your former Sunday school teacher that I thought she captured very well the person that we didn't know that she does know and did know. So it will be the order of the court that the court, with some hesitancy, but finalized, that after due consideration, the court finds the defendant is not amenable to available community control sanctions. The court does intend to follow the stipulated prison term, and it will be imposed that the defendant shall serve the stipulated prison term in count 3, of 30 months, a stipulated prison term in count 5 of 30 months, which shall be served consecutive to count 3, and a stipulated prison term in count 7 of 30 months, which shall be served concurrent to counts 3 and 5 for a total of 5 years incarceration in the Ohio Department of Rehabilitations and Corrections. Because multiple prison terms are being imposed on Ms. Hawkins for convictions of multiple offenses, the court may require that she serve them consecutively. Because the court finds that consecutive service is necessary to protect the public from future crime and or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct or the lack of conduct and to the danger that it poses to the public. And the court makes the finding that at least 2 of the multiple offenses, in this case 3 offenses, that 2 of the multiple offenses, at least 2 of them, were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed is so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct would adequately reflect the seriousness of the offender's conduct. The court finds that the defendant's placement or transfer into a transitional control program under 2967.26 while incarcerated, or her placement or transfer into an intensive program prison under 5120.032, both are hereby specifically reserved by this court for denial upon notification that the Ohio Department of Rehabilitations and Corrections desires consideration of the defendant for transitional control or for the intentional program prison. The court further notifies the defendant that post-release control is mandatory in this case upon your release from prison. And that will be up to 3 years maximum, but no less than 1 year. If, while under post-release control, you violate post-release control sanctions or any conditions imposed by the Adult Parole Authority or the Parole Board under Revised Code Section 2967.28, the Parole Board may impose more restrictive sanctions upon you, a prison term not to exceed 9 months for each violation, or a maximum cumulative prison term for all violations not to exceed 1/2 of the originally stated 5-year prison term as originally imposed. But if the violation of your post-release control is the commission of a new felony offense while under post-release control supervision, then you may receive a prison term of the greater of 1 year or the time still remaining under your post-release control supervision up to that 3-year period on any or all of the 3 charges. And that may be required to be served in addition to or consecutive to any other prison sentence imposed for the new felony offense that would be committed that caused you to violate your post-release control. Your order to serve as part of the sentence any term of post-release control imposed by the Parole Board, as well as any prison term for violation of that post-release control. The defendant is therefore ordered conveyed to the custody of the Ohio Department of Rehabilitations and Corrections by the Adams County Sheriff's Department. She shall receive credit for 345 days as of today's date of June 17th, 2026. And as statutorily entitled, she'll also receive credit for any future custody days while she awaits transportation to the appropriate state penal institution. Ms. Hawkins, you're hereby notified that you may be eligible to earn days of credit under the circumstances specifically defined in section 2967.193 of the Ohio Revised Code. You're notified that these days of credit are not going to be automatically awarded to you, but they must be earned in a manner specifically outlined under section 2967.193. The court finds no beneficial matter of imposition of a fine upon Ms. Hawkins in this case, and so there will be no fine placed upon Ms. Hawkins. Any money that she may earn through state pay, I hope she sends that back for the benefit of her remaining 2 children. The defendant is ordered, though, to pay all court costs of the prosecution of this action for which execution is awarded and any fees permitted pursuant to section 2929.18A4 of the Ohio Revised Code. The Department of Rehabilitations and Corrections is ordered to withhold funds in the appropriate amount from the defendant's account to pay these most limited financial sanctions. Under section 2947.23A1A, if you fail to pay these limited financial sanctions or fail to make timely payments on these financial sanctions under a payment schedule approved by the court, then the court may order you to perform community service in an amount of not more than 40 hours per month until the judgment is paid in full or until the court is satisfied that you're in compliance with an approved payment schedule. Under section 2947.23A1B, if the court does in fact order you to perform community service in lieu of or in exchange for the non-payment of the financial sanctions, then Ms. Hawkins, you will receive credit at a specified hourly credit rate. For every hour of community service you perform, it will reduce the judgment by that amount. The court does find that the defendant does have the past, present, and future earning income ability to satisfy these financial sanctions. Again, I noted the admirable work ethic of Ms. Hawkins in that she was a manager of 2 very active fast food branches in our community, and she's also served in capacity with a 3rd. She'll be able to earn state pay of $17 to $22 per month, and again, because of the limited financial sanctions, the court finds she has the past, present, and future earning income ability to satisfy these financial sanctions. There was not a cash bond posted in this case for the court's consideration of return to the surety for compliance or forfeiture due to noncompliance. The defendant shall be required to submit to DNA testing pursuant to Ohio Revised Code section 2901.07. Before I give the appellate rights, I'll start with the state. Do you feel that the court has complied with the stipulated sentencing agreement as presented to this court?
Yes, Your Honor.
Defense counsel, same inquiry.
Yes, Your Honor.
Very well. Ms. Hawkins, do you believe the court has imposed the sentence that you had stipulated or agreed to with the state of Ohio?
Yes, Your Honor.
Ms. Hawkins, this is now a final appealable order. You have the right to appeal this court's decisions, but you must do so in a timely manner. You must do so within 30 days of today's date, for I intend to sign this judgment entry of sentence today. As a United States citizen, if you cannot afford the cost to file that appeal, then you have the right to file that appeal free of charge. If the court possesses documentation that you need to promote your appeal of this court's decisions, then upon your request, again, the court will provide those documents to you free of charge. If you cannot afford the cost to hire counsel to represent you effectively, as the court firmly believes that both Ms. Carrington and Mr. Walker have done in this underlying matter, then upon your request, the court shall forthwith or right away appoint an attorney to represent you. But you will be required, Ms. Hawkins, to pay a $25 energy counsel fee fund. Ms. Hawkins, I stress to you and I emphasize to you, you must file that appeal within 30 days of today's date. Ms. Hawkins, do you feel you understand your appellate rights?
Yes, Your Honor.
Ms. Hawkins, did you understand that you must file that appeal within 30 days of today's date?
Yes, Your Honor.
Do you have any questions about your sentence or your appellate rights?
No, Your Honor.
State of Ohio, do you have anything additional or objections you'd like to have noted at this time?
No, Your Honor.
Ms. Carrington and or Mr. Walker, anything additional or objections you'd like to have noted at this time?
No, Your Honor. Thank you.
Ms. Hawkins, is there anything else you would like your counsel to bring to the court's attention before we conclude today's hearing?
No, Your Honor.
Ms. Hawkins, I always appreciate the courtesy that you have always extended to the court and the court staff throughout these proceedings, and we thank you for that courtesy extended. We're off record.
Pre-trial on Youngberg. Some time.
Good.
12's trying to get a hold of me as I ain't starting, so I'll run.
Yes, I absolutely will.
Thank you.
Ms. Riley, thank you.